So, this is an update to the Holderman case. If you haven't watched the Holderman case, you better watch it and catch up because we have like 5 hours worth of crazy fighting to figure out who gets Uncle Larry's money when there's any left, if it's not taken up by attorney's fees. And during the last hearing, I'm pretty sure that they decided to dig up Brother Johnny. So, if you ignored what I just said and you didn't just hit pause and go watch the last hearing, or you just have a bad memory like me, here's your TLDR. And if you've never read it and you don't know what that means, too long, didn't read. TLDW, too long, didn't watch. All right, so Uncle Larry Holderman did what we all should do, and he made a will back in 1999. Doesn't it seem like yesterday and forever ago? So he had two children that he was estranged from, and we don't really know the circumstances surrounding that, but he specifically excluded them from his will. He lived on a farm with his parents and he left everything to them in his will. Problem was, his parents died before him, so did all his brothers. This led to this epic legal battle between the disinherited children who were excluded in round one and plan on appealing, of course, their children, which are the grandchildren. There's a known niece and an unproven niece. Now, the unproven niece was born to Uncle Larry's half brother out of wedlock, and she was never legitimized, as they call it in the eyes of the law. This has led to this huge battle between the attorneys on how to accomplish proving that she is a legitimate descendant of this family. So her attorney has offered all different kinds of proof, and the attorney for the known niece, who is the only one involved because the disinherited children have kind of got pushed to the side and the grandchildren are like, screw you, I want nothing to do with this. The known niece is like balls to the wall fighting this. The unproven niece is like, well, here's my info. She's like, no, not working. So it's getting kind of crazy. Now, we've been following this case for a while as they go back and forth on how to prove this paternal link. And in the process, we found there's quite a backstory there. And I just want to give a shout out to Northwest for the help in a ridiculous amount of research in this case. I now have a whole family history on these people in Kansas. But talk about digging, really. Wow. We've we found some interesting things. One of the things we found, though, was the obituaries for both Clara and Frank. So those are the grandparents, and because of the way everything worked out and the anti-lapse statute in Kansas, which says if the people named in the will are no longer living, instead of the will just becoming lapsing or becoming invalid, it passes on to their next heir. So everything that Larry had passed up to his parents, but with the anti-lapse statute, it would pass down to the next heir. Because that next generation is all deceased, it would go down again. That would be the generation of the nieces and the two disinherited children. Now, we know of the four brothers, Johnnie Rex, which is Susan, the unknown, unproven niece's father, was only Clara's son. She had him before she met Frank, and they had the other three boys. So if you look at her obituary and you look at the number of children and grandchildren listed on her obituary, it's interesting because if you compare that to Larry's obituary, you notice there's a strikingly different number of children, grandchildren, great-grandchildren, and all of that listed. And because of when they died later in life, I don't think they were still populating out children and grandchildren. If you add the numbers up, it totals out to Clara including Susan and her children in her obituary. They're not specifically named, but they are included in the numbers in the count of how many children and grandchildren. They are not included in Larry's, which isn't really that unusual. Some people include stepchildren and their grandchildren, some people don't. It's just some people like preserving that DNA record. Some people think that family is family and it doesn't matter if there's a blood relation or not. So why do the obituaries matter? Well, to me, I find it interesting for the fact that the only people who were living at the time that Clara passed would be Uncle Larry, his brother Dennis, who is known niece Mandy's father. And remember, Mandy's the one who's dragging this out, fighting, trying to exclude Susan from the estate. So you would think of the two relatives living plus Mandy. So it would either be Uncle Larry, Uncle Dennis, or Mandy, who went to the funeral home and filled out those forms and wrote down how many children, how many grandchildren, and decided to include Susan's children in that. I wonder who filled out those forms. Inquiring minds would like to know. Also, since the last hearing I streamed the right word? I'm never sure. Like, you show something on TV or you air it, but this isn't TV. Anyways, in an odd twist, a document was recently filed that indicates that Uncle Larry attempted to amend his will. He tried to do the right thing. He tried to update it after everybody around him died. Poor thing. However, he didn't follow the proper procedures and the amendment was not accepted. Like, you can't just write it on a napkin or a post-it note and say, hey, I want to change this. Kansas Statute 59-606 outlines the requirements for the execution and attestation of a will. Any changes to the will need that same attestation. The preferred method is to create a new will that will replace the prior will, since codicils can become confusing. So let's take a quick look at that. The document I referenced was an affidavit from Mandolin Holderman. In the affidavit, Mandolin indicates that she received a letter with a proposed settlement agreement almost a year ago. She says she had no idea who Susan Davenport was and that she had never met her. She had never heard her uncle or her grandparents mention Susan, and makes it sound like Susan's total wackadoo off the street who's just trying to con them out of money, which I find incredibly interesting given the statements by Susan, who I find credible if you watch the emotion that she speaks with, and the evidence that I've seen so far all matches her story.
And including Mr. Mills's client, has known my client since 1989, has met her several times, has called her cousin, but now doesn't once this has come up. There are pictures. My client was in the obituary. She is listed on the headstone as the daughter of Mr. Kennon. I realize that that is not DNA evidence.
The letter came from Mr. Wetta's office, who, if you'll remember, is the attorney for the estate itself. And the executor of the estate is someone who was associated with Uncle Larry prior to his death, a caretaker or financial something. Somehow she was associated with him. I'm not sure exactly the details. And it shows that the estate and the representatives did their due diligence in tracking down all the heirs to the estate. And Susan Davenport was a known heir. So she got a letter and they sent the letter out and explained everything. And one of the things they explained in this letter was that Uncle Larry had attempted to amend his will. However, it didn't follow the guidelines. But in that amendment, he tried to leave everything to his uncle, Edward Bunyard, who is, I believe he's almost 90, and that is his mother, Clara's brother, who has no part in this at all. Like, none. None. Just interesting. But it also shows that Susan didn't get wind of Uncle Larry passing and try and jump on the gravy train like Mr. Mills is Mandolin's attorney, has alleged, suggested, inferred. It's kind of ironic that this case has garnered so much attention, really. It's been one of the most popular cases that I've covered, and the subject matter is what makes it ironic, because this is the one class that I barely passed in school. And I still hate this area law. It is ridiculously complicated and it turns a loving family into vicious, money hungry villains. It's horrific what people do when they get in these situations. Anyways, so it's unfortunate that the amendment didn't meet the required legal criteria, as it seems like Uncle Larry didn't want any of these people to have his money. And he's probably rolling in his grave, but we won't know that because it's not him that we're going to dig up. It's his poor half brother, Johnnie Rex. Johnnie was the oldest of Clara's boys. Actually, she didn't go by Clara, she went by Lodima. So, Grandma Lodima married Lloyd Kennon and she had Johnnie Rex. And not long after, something happened to that relationship. I don't know all the details to that, but she ended up marrying Frank Holderman, and then they had the 3 more boys. When he was 19, Johnnie Rex Kennon enlisted in the Kansas National Guard. It was right around the same time that he had a relationship with a local girl who ended up pregnant. Her family did not like Johnnie Rex, wrong side of town, I guess, wrong side of the road, wrong side of the dirt road. I don't know. They lived in rural Kansas. Ultimately, the baby was put up for adoption. On the baby's birth certificate, the mother's name was listed, all her information. The father's name was left blank, and it said not unknown. Not unknown. Like, it's known, but we're not going to list it here. It would later be revealed that the baby was Susan Davenport and her father was Johnnie Rex Kennon. However, it was never officially put on a birth certificate because she was adopted. That's why we have all this craziness. Johnnie served 6 years with the National Guard. Then he worked as a horse trainer and a jockey. He got into a bit of trouble throughout the years, but nothing major. No felonies, never got a lengthy prison sentence, nothing. In the late 80s, he had a connection with a guy named J.C. Woodall. Woodall was a bit older, about 18 years older, I think. He lived down the street when Johnnie was growing up, and so did his brother. So they knew them for a while. We know this from the 1960 Kansas census records. Genealogy is a great thing. So J.C. Woodall made his money as a metal scrapper. He was from Alabama, went to California for a stint, got hitched, then came back and settled in Eureka, Kansas near his older brother, J.W. And I'm honestly not sure if J.W. and J.C. have actual names. I'm pretty sure they don't, that it's just initials. So, when you have that many kids, after a while you run out of names, so you just start throwing out letters. Kidding. Kind of. So J.C. Woodall was engaged in this long-term dispute with the other Woodall family members, a decent-sized family back in Alabama, over this property in Elmore County, Alabama. It's near the city of Tallahassee, not to be confused with Tallahassee, Florida. Tallahassee with no H. Everything's got to be confusing. So JC started to just absolutely hate his younger brother, Elmer Woodall, not to be confused with Elmore County, Alabama. Elmer Woodall, who they called Stormy. It's just, everything is so similar. So Stormy had actually bought some of the property or acquired some of the family property, and JC was pissed because he thought he should have got it. So there was some litigation involved in this property, and they were going back and forth in court and all of this. So during the settlement efforts, Stormy Woodall had drawn out a sketch of the property. It was about 37-acre tract of land, and he mailed it to JC. JC lived in Kansas. He drew it by hand, colored it in, mailed it to him. This is important. Remember that. So sometime between March and April of 1989, JC calls up his acquaintance, John Kennon, and he asks him, hey, can you go to Alabama, take care of a problem I've got? There's some guy beat me out of some land. He's been giving me some problems, caused me to lose a lot of money. John Kennon's like, hell no, but I know a guy. $200, I'll introduce you. We all know a guy, right? So in April of 1989, John Kennon introduced J.C. Woodall to someone named Freddie Glenn Pope. Woodall agreed to pay Pope $3,500 to take care of his Alabama problem. So his Alabama problem turned out to be going and killing his brother Elmer Stormy because of this land dispute and his hatred for his brother. So Pope agreed, but he kind of hid the fact that he was going to do it himself. He led JC to believe he was going to get somebody else, 6 degrees of separation and all of that. So JC and a lady friend take a little road trip around the end of May 1989. Back to the heart of Dixie. I have no idea what happened to his wife. I couldn't find all the details. Plus, this was like too much. While he was there, he conveyed to his mama, Climmer, a life estate of 37 acres of land. So Stormy later testified that the conveyance completely caught him off guard because it wasn't even part of the settlement agreement that they had reached in the land dispute. This was totally different. So he had no idea what was going on. But whatever, my brother's weird. We ignore him. Now, a month later, this was after he had already, shook hands with Pope and made that deal. So a month later, Pope arrives in Alabama. He checks into the Budget Inn motel, takes a drive over to the residence of the man that, this is his target. No one's home, but he notices a new car in the carport. And that kind of bothered him because he was told that Elmer Stormy lived alone. So if he's not home, whose car is in the carport? He comes back the following morning. This is Monday, June 26th. And he found that Elmer was there, but he had several other people there working with him on the house. He also observed off in the distance there was a woman. She was over by a pond behind the house. So Pope walks up to Elmer and told him he was a contractor from Mississippi. He was interested in purchasing a large quantity of gravel. Elmer had a lot of gravel on the property. And while he was there, he showed Elmer the map of the property that Elmer had drawn and given to his brother JC. JC had given that map to Pope to help him find the property to complete the hit. So Elmer immediately recognized the map and thought something was off because, hey, look, that's the map that I drew. He didn't really know what was going on, though. He just knew something was hinky. So Pope left the property. He calls JC from a payphone. They have all these phone records and everything in all the court records. And he starts questioning him about the car that's in the driveway, about the woman that's there, everything that's going on. JC says, oh, it's probably the man's sister from Florida. Pope doesn't know that this is JC's family. JC knows that's his mother because his mother lives with him. This is where it gets bad. Pope later testified he told JC in another conversation he was very concerned that the plan wouldn't work because that woman can't be around there. That's a quote. That woman can't be around there. To which JC responded, quote unquote, if she gets in the road, she has got to go. That's his mother. I mean, brother's bad enough, but let's step it up to mother. If she gets in the road, she has got to go. So Pope goes back a couple hours later. He goes up to Stormy, asked to use the phone. 1980s, didn't even have cordless phones. Had to go in the house with the cord. So Stormy's leading him up towards the house, and Pope pulls out a pistol and says, this is nothing about no telephone conversation. This is a robbery. Pope tried to pull Elmer into the house to prevent anyone from hearing, but Elmer started fighting him. And so he was pulling him back towards the yard. So Pope just went ahead and pew in the noggin. So Mama Woodall heard all this and started screaming. Pope tells her to shut up. And she's still screaming because she just saw, her child. Pew. Hate YouTube censors. He pew her. Same way. Same place. And then he looks down and Elmer's still making noise after 2. So he threw a couple more in there. And then he hauled ass. Remarkably, however, Elmer survived, Elmer Stormy, and was able to provide information to law enforcement that allowed them to identify and arrest Pope, who quickly confessed and implicated Woodall and Kennon. One of the things he saw, in addition to the map, he also saw the wheat on the license plate and put that together that they were from Kansas. So Pope was arrested in Kansas pretty quickly, and he waived extradition, transported back to Alabama. And imagine his surprise when he learned the backstory to all that and who they were and how they were connected to JC, because he was told it was just a land deal gone wrong and these were random people. So 2 weeks after this, on July 14th, 1989, an Elmore County, Alabama grand jury returned a 4-count indictment against Johnnie Rex Kennon. They also returned the same 4-count indictment against J.C. Woodall and Freddie Glenn Pope. All 3 men received the exact same charges. Both J.C. and Johnny were arrested in Kansas that day, and they were held on a $100,000 bond pending extradition. Now, most of you are probably like, oh, cool story, bro. Thanks. And are like ready to log off, but like that was like the intro. This is where the crime ends and the massive legal battle begins. So Freddie Glenn Pope waived extradition right back in Alabama the next day. Kennon and Woodall dug their heels in and said, make me. On July 28th, 1989, Kennon filed a petition for a writ of habeas corpus. Woodall did as well. They remained in Kansas while these cases worked their way all the way up to the Kansas Supreme Court. Let me explain the basics of the extradition process. So the grand jury in Alabama issued the indictments. The district attorney in Alabama knows the fugitive is in Kansas, in this case, Kennon and Woodall. They submit an application for extradition to the Alabama governor, which states, importantly, the offense was committed in Alabama. So it went on to list the charges, and then it stated that said accused is now a fugitive from justice in this state and is believed to have taken refuge in the state of Kansas and is at the present time in or near Wichita in that state. That it is necessary for the ends of justice that said fugitive should be returned to the state of Alabama. In response, the governor of Alabama made a demand on the governor of Kansas for Kennon and Woodall's extradition. So in response, Kansas Governor Mike Hayden issued a warrant for Kennon and Woodall's arrest. So the basis of the objections filed by Kennon and Woodall were that the grounds of the warrant and the indictment were invalid because Kennon had never been to Alabama, ever. And therefore, he couldn't have been the principal in an act that was committed there, nor a fugitive from justice. Woodall's objections were slightly different, but I'm not going to go into that because that's going to get way too confusing. Agents from the Alabama and Kansas Bureau of Investigation testified to the facts of the case and that Freddie Glenn Pope was the individual who actually committed the crime. All of the crimes committed by Kennon, which were openly discussed by Kennon, were committed in the state of Kansas. In response to Kennon's argument that the warrant and the indictment were invalid because he was not a principal and thus not a fugitive, as stated in the warrant, the state contended that the trial court held that Kennon was a fugitive under KSA 22-2706, which allows extradition when a person has committed an act outside the demanding state intentionally, resulting in a crime in the demanding state. They relied on Greenbaum v. Dar, which is a Kansas case, and an Alabama statute providing jurisdiction for crimes beginning outside of Alabama but ending in Alabama. The trial court further held that the failure of the extradition documents, and in particular the indictment, to allege that Kennon's acts were committed in Kansas and not in Alabama was not a fatal flaw to the extradition. Accordingly, the court dissolved the writ of habeas corpus previously issued by extradition that was stayed pending appeal. The Court of Appeals affirmed this in an unpublished decision. This took it up to the Supreme Court, which accepted the petition for review. Now, I'm not going to go into detail about the opinion. It is quite in-depth. The Kansas Supreme Court decision on the case was written by Chief Justice Holmes. And ultimately, the decision of the Court of Appeals was reversed. Like I said, it's very lengthy, but just a couple of the issues that were asserted by Kennon was, One, whether the district court erred in failing to grant Kennon's petition when no facts proved Kennon was a fugitive from justice as required by the Kansas statute. Two, whether the district court erred in failing to grant Kennon's petition when the extradition documents were framed under the statute, depriving Kennon of the gubernatorial discretion, which is his due process right. So once the Supreme Court reversed the decision, the cases were remanded back to state court. While all this is going on in Kansas, Freddie Pope was facing a jury in Alabama for his role in the whole to-do. He was sentenced to life in prison. He appealed, but his conviction was upheld the next year. So in the second round of cases, because they appealed, they went all the way up to the Supreme Court. The Supreme Court agreed with them and sent it back down. So then they have to do it again. The second round of cases and appeals was not without controversy either. Both sides were pretty vocal in the newspapers and lashing out at each other. Kennon's defense attorney, Roger Falk, blamed the Kansas district attorney for not prosecuting the two in the state of Kansas because both of their crimes were committed in the state of Kansas. The district attorney, in turn, said they were hiding out and abusing the legal system. But because Alabama decided to prosecute them, they had to go through the process. So the first extradition order was signed by Kansas Governor Mike Hayden, but that was thrown out by the Supreme Court when they're like, you didn't ask right. So then Alabama tried again. But by this time, there was a new governor in Kansas. That was Governor Joan Finney. And initially, she refused to sign the order outright. She was a staunch death penalty opponent and was not going to extradite two men to a state that was going to prosecute them for a capital crime with the death penalty as a punishment. Eventually, she relented and she allowed the extradition to proceed, but she put the caveat in there that only if the death penalty was taken off the table. One of Governor Finney's staff members commented that they felt like she was even more concerned about this case because she had recently learned about the malfunctions of the Alabama electric chair, which were described in very graphic detail in news articles. I believe this is likely referencing the 1983 execution of John Lewis Evans. Alabama's chair is known as Yellow Mama. It's painted with yellow traffic paint. It's an interesting name, not quite as iconic as Florida's Old Sparky. The following description of Evans' electrocution was sworn by Evans' attorney, Russell Cannon, on June 22nd of 1983. At 8:30 p.m., the first jolt of 1900 volts of electricity passed through Mr. Evans' body. It lasted 30 seconds. Sparks and flames erupted from the electrode tied to Mr. Evans' left leg. His body slammed against the straps, holding him in the electric chair. His fist clenched permanently. The electrode burst from the strap, holding it in place. A large puff of grayish smoke and sparks poured out from under the hood that covered Mr. Evans' face. An overpowering stench of burnt person and clothing began pervading the witness room. Two doctors examined Mr. Evans and declared, "Not yet." The electrode on his left leg was refastened at 8:30 p.m., which is not correct. Mr. Evans was administered a second 30-second jolt of electricity. The stench was nauseating. More smoke emanated from his leg and his head. Again, the doctors examined him. They reported his heart was still beating. At that time, I asked the prison commissioner, who was communicating on an open telephone line with the governor, George Wallace, to grant clemency on the grounds that Mr. Evans was being subjected to cruel and unusual punishment. The request for clemency was denied. At 8:40 p.m., a third charge, 30 seconds in duration, was passed through. Finally, at 8:44, he was pronounced. It took 24 minutes. Ouch. Back to Finney, the Kansas governor and the death penalty opponent. Ironically, at the same time, she was refusing to allow Kennon and Woodall to be extradited until the DP was taken off the table. She was about to sign a bill to allow it to be the law in the state of Kansas. Explain that one. So, the wording in the warrant and Governor Finney's responses were largely the subject of Kennon and Woodall's second petition for habeas corpus relief and the subsequent appeals, which went all the way up again. I believe part of the problem, which was apparent to anyone who read the details of the case, was that Alabama was zealously prosecuting Kennon and Woodall to an extent, with extreme charges carrying the harshest penalties possible when they were not the principals in the crime. And Kennon, more so than Woodall, had minimal involvement or knowledge of the crime itself. Like, it's unknown if Kennon even knew the crime had taken place when he was initially arrested. His involvement ended at introducing Woodall to Pope, as far as all the evidence, including his confession, show. Speaking of confession, shortly after being arrested, Kennon was actually hospitalized at the Wesley Medical Center psychiatric ward in Kansas. And while being treated and considered a mental health patient, he was interviewed by the Kansas and Alabama Bureau of Investigation detectives. Of course, there's no audio or video recording of this, but during this interview, Kennon confessed to his involvement in the crime, and this confession was used against him along with statements made by Pope, which were the only evidence showing that he had any involvement at all. Yet he was charged the same as Pope and Woodall. Also, during his years in Kansas jail fighting his extradition, Johnnie Kennon was diagnosed with cancer. J.C. Woodall required heart surgery. The Sedgwick County Sheriff's Office put out a statement estimating their medical expenses cost the county over $250,000 during the extradition fight. This announcement came in early 1995 after the 10th U.S. Circuit Court of Appeals in Denver returned an unfavorable decision against Kennon and Woodall. Kennon decided to drop the fight. He was done, waved the white flag. He was going to allow extradition. But Woodall, on the other hand, said he was going to appeal to the U.S. Supreme Court. But then on May 22nd, 1995, both Kennon and Woodall were transported to the state of Alabama. Kennon's Alabama defense attorney immediately filed motions to have his confession, which was referred to in prior hearings as being taken in a hospital. Yeah, let's leave out that mental health component. There was also motions for a competency evaluation. Prosecutors were eager to get the trial going as quick as possible, like as soon as Woodall's boots hit the ground, but he had more delay tactics in mind. He motioned the Alabama Court of Criminal Appeals for a delay, and then the appellate court to honor the condition placed on his extradition by Kansas Governor Kinney. That was to take the DP off the table. But everything was denied, and Alabama didn't care. They were prosecuting to the full extent. Woodall's attorney was quite the eccentric litigator. This was very My Cousin Vinny-ish. He stated during arraignment that Elmore County was not the proper jurisdiction for this case. And then Woodall, obstinate as ever, refused to enter a plea. His attorney, Mr. McDuffie, who looks kind of like Gary Busey meets The Office, I don't know. This photo is obviously from a couple years later when he had some trouble of his own, stated that his client was kidnapped and brought back to Alabama, which is kind of true. He technically had a right to appeal the 10th District Court's decision up to the Supreme Court. And while it's highly unlikely that the Supreme Court would have taken his case, that was still his right. Alabama seemed to be going a little Wild West style, in my opinion, or good old boy Southern style. Yeah, that's the thing. So J.C. Woodall's trial started first, and that was in December of 1995. And his brother and nemesis, Stormy, testified against him. Even though he survived, he had 2 pew-pew wounds to his head. He was mentally disabled from the wounds. He testified that as his mother laid there in what they expected to be the last moments of their life, he remembers managing to mutter, "I love you" to her. He also recalls hearing her scream as Pope fired at him, "Oh no, not my baby." Elmer had his eyes closed most of the time he testified. He spoke slow, with slurred speech, and had to ask for questions to be repeated several times. At one point, Elmer stood just feet away from his brother JC, looked at him tearfully, and said, "I saw Pope go over there and shoot our mother." Other members of the Woodall family sobbed. It was a very emotional moment. Stormy testified that they knew JC had sent the hitman because Pope carried with him the map that Elmer had drawn himself and then mailed to JC months earlier. The local newspapers printed summaries of the case every day. It was like the daily soap opera. One thing I don't know if I mentioned before is John Kennon had no felony convictions on his record prior to being arrested in this case. JC had some, but nothing super serious. He wasn't a great person, but his criminal history on paper that I could find wasn't horrible. John, on the other hand, didn't have hardly anything, like a couple burglary charges, petty thefts. One time he stole a dog and a gun, disorderly type things. So this was crazy compared to his criminal history. So on the second day of Woodall's trial, Pope testified. The summary in the local newspaper begins with a criminal history so long and a reputation so bad that people would scare little kids with my name. Freddie Glenn Pope confessed that he was not the best person in the world, but he said he was never low down enough to order his own mother. If you recall, at the time, Pope didn't know that Clemmer was JC's mother. He thought these were random people from a land deal. The defense attorneys asked for a mistrial several times because of things that were said during the trial. They also argued that Woodall was set up by Pope and Kennon. To keep things at Hollywood level, during a sidebar, a radio station reporter was called to the stand after allegations that the jury had been prejudiced by facial expressions and grins from Circuit Court Judge Steve Drinkard. She said the jurors didn't appear to be taking the testimony seriously and were out and out giggling during cross-examination of Johnnie Kennon. Yes, Johnnie Kennon was called to testify and did testify against JC Woodall. The judge responded by denying the motions and saying the statements were consistent with the defense not wanting to try the case from the beginning. On day 3 of the trial, Woodall testified in his own defense, although he didn't seem to recall much. He did know that he did not hire anyone to go after his mother and brother. He testified that he did not know who Pope was, had no idea what he had against him or how he had offended him to make him testify the way he did. He did admit that he didn't particularly like his brother, Stormy, but he would never do this. The jury deliberated for 3 hours before returning a guilty verdict. The penalty phase began immediately, even though it was a Saturday. This was high priority, high profile, like big news. There were 2 options: life without parole or Yellow Mama. Character witnesses for Woodall testified he was a very good person, honest, trustworthy, all the normal things that character witnesses say. Those words weren't enough to overshadow the testimony of Woodall's son, who recalled an event from years prior when he and his father were playing a pickup baseball game, and his father had beat him with a bat during the game to the point that he went to the emergency room. Late Saturday, December 9th, 1995, the jury unanimously recommended the DP for JC Woodall. The judge still had to make the decision and actually impose the sentence, though. That officially happened a month later. And in keeping with his character, Woodall stood up, called the judge a zealot, and said that the judge was not qualified to settle a milk bill. Stormy Woodall told the press, "I want everybody to know the system does work, and I'm happy with the outcome." JC Woodall was sent to Alabama's death row. Freddie Glenn Pope, the principal, was serving life without parole. And shortly after this, Johnnie Rex Kennon avoided a trial by accepting a plea deal for manslaughter. and a 15-year sentence, which included time served back to 1989. His release date would have been 2004. Interestingly, for her work on the case, his attorney was paid a whopping $20 per hour. I know, it was 1995, but that's about $40 in today's money. Her pay was increased to $40 if she was going to trial or appellate level preparation. Find me an attorney today who will work for those prices. The plea agreement for Johnnie Rex Kennon was signed on March 15th, 1996. Unfortunately, he died 2 months later from the cancer he had been battling since he was in the Kansas jail on May 13th, 1996. We do know from his daughter Susan's testimony at the estate hearing that he was given a compassionate release the final 2 weeks of his life. I'm going to assume this was part of the plea deal, in addition to him testifying against Woodall. JC appealed his conviction, which is required in all DP cases. The reasons stated were that there were errors related to his extradition and not being allowed to continue his appeal process, and the Kansas governor's order to take the DP off the table was completely ignored. He also argued that the trial court judge erred in not recusing himself when he was also presiding over a civil issue between JC and Elmer that was going on at the same time. The civil dispute over the property had drug on and was not resolved. And in this small town, there aren't a lot of judges, everything else. The same judge was presiding over both issues. The appeals court upheld the convictions, but JC didn't give up. He appealed all the way to the Alabama Supreme Court. And even though all of the lower courts ruled against him, the Supreme Court found an issue. During cross-examination, the prosecutor asked JC if he had ever beaten anyone with a baseball bat, to which he responded no. Then they called his son as a rebuttal witness. They argued that him responding no opened the door to allow them to put his son on the stand to give the testimony about being beaten with a baseball bat. Generally, that testimony would not be allowed. The jury was instructed that it was to consider evidence of the defendant's violent past acts only for the purposes of impeachment, and that it could not use the evidence to draw any conclusions regarding his character. The Supreme Court issued a lengthy opinion, but basically said that wasn't opening the door. They have to open the door. They didn't. Sorry. As a result of that, his life sentence for attempted was upheld, but the DP was reversed and remanded for further proceedings. So now it's 2001. JC is back in regular court for a new trial on the capital charge. Pope and Kennon's testimony from the prior hearing was read into the record, and Woodall was again convicted. This time, he received a life sentence. About 4 years later, in 2005, Woodall himself died. 4 years into his life sentence. Now, some people are going to believe that anyone who would introduce someone to a quote-unquote hitman is not a good person and probably deserved to be in prison. Looking at what happened, Johnnie Rex Kennon, who was not Citizen of the Year, but definitely was not a garbage human being, for introducing Woodall to Pope, received his $200 fee, I believe, and 6 years, 8 months, and 1 day in prison. Is that just? I don't know. But fortunately, Susan was able to reconnect with her father before he passed, and they were able to spend those last 2 weeks together. To be honest, there is a lot more to this story. Like, we found we could go on and on forever. It's a very interesting case, but it's quite the legal entanglement. We also did some digging and found out known niece Mandy might have some motives for wanting the money all to herself, but we'll have to get a little bit more information before we talk about that one. It's been an interesting journey into the Holderman history. Hopefully they will be able to find some kind of connection and they won't have to dig up Johnnie. Go make sure you have a will. Take care. Thank you. Just as I was finishing up the editing and hoping to finalize this, there was a new order filed in this case, entitled Order Determining Susan Davenport to be Beneficiary of the Estate. It seems the parties came to some form of agreement. We don't know exactly what, but they have agreed. They filed that agreement with the court, and the court issued the following. The court, after hearing the announcement of counsel and being otherwise familiar with the facts underlying the agreement, finds that based on considerable evidence and proffers of evidence previously presented to the court of her relationship to Johnnie Rex Kennon, the half-brother of the decedent, as well as the agreement of the parties, Susan Davenport shall be designated as a beneficiary of the estate of Larry Holderman. Furthermore, Susan Davenport is determined to be a beneficiary of the estate pursuant to her relationship with Clara Ledema Holderman as Clara Ledema Holderman's granddaughter. It is so ordered. Now, we wait for the children's appeals.